destruction of evidence. At the end of my presentation, I shall address the second question put by Judge Cleveland. Mr. President, Myanmar does not challenge the fact that the court can grant the Gambia's application as concerns the declaration of responsibility for the genocide and the declaration of breaches. Myanmar does not either challenge the fact that the court can grant the Gambia's applications as concerns and requests concerning the cessation of the continuous violations. You know our claims, and you will soon hear the final submissions of the Gambia. Not one of these group by its security forces during the clearance operations. Members of the court, a genocide was committed. Let it be said, and said clearly, plainly, without animosity, without any political ulterior motives, as indeed your oath commands. Myanmar hasn't challenged the fact that the genocide is a composite international wrongful act. Its responsibility thus goes back to its first attacks in October 2016 and encompasses every constituent act of Actus Reus. Myanmar has not challenged the fact that the members of its armed and police forces involved in the clearance operation acted as such, and that their conduct incurs its international responsibility. The fact that they breached the rules of engagement is, from a legal point of view, unimportant as concerns the attribution of their conduct to Myanmar. Myanmar has not challenged that. During the clearance operation, a number of people likely committed acts of genocide under the instruction or directive or control of the military. Such acts are therefore attributable to Myanmar under Article 8 of the ILC's articles and your jurisprudence. Regardless, and whatever the case may be, Myanmar has not challenged the fact that under Article 1 of the Convention, it had to prevent acts of genocide committed by individuals taking part in clearance operations alongside the security forces. Thus, Myanmar failed to comply with its obligation to prevent such acts, and the Gambia asked that the court declare that indeed, as is the case for the other wrongful acts identified in our final submissions. Which leaves us with the issue of reparations and assurances and guarantees of non-repetition. Of justice. You heard 3 surviving victims, but there are, unfortunately, thousands, hundreds of thousands of others in camps in Bangladesh. Each and every one of those victims deserves justice and awaits justice. Your decision, of course, in this respect must be based in law. And despite the unprecedented nature of the case, and contrary to what Myanmar says, there is no legal obstacle to it. The first question is, does the court require another basis for jurisdiction than Article 9 of the Convention to decide whether Myanmar must make reparations? Myanmar states that it is indeed so, because the harm was suffered by persons not of the applicant state's nationality. Let me not repeat what I said in the first round, but let me just say that what I said about the argument about interpretation of Article 9 was not challenged, or at least responded to, by Myanmar. Gambia holds that the jurisdiction of the court to rule on the issue was settled by your judgment of the 22nd of July 2022. Admittedly, the court did not find that an obligation of reparation in the interest of the victims existed, but it did indeed hold that it had jurisdiction to decide whether such an obligation exists in customary law and whether Myanmar owes it. In this respect, your decision is res judicata. Were the court now to find that such an obligation does not exist, then the question of whether the Gambia has standing to demand the performance falls. However, should the court consider that such an obligation does exist, then no additional basis for jurisdiction would be required to decide that Myanmar owes an obligation. The only outstanding question would be to see whether the Gambia has standing to ask for the performance of the obligation by Myanmar for the victims, and I'll come back to that. If the answer is yes, then there is no additional basis for jurisdiction required to rule on the remedies sought. The parties disagree on the existence of for the state responsible for genocide to make reparations for the harm suffered by the victims when they are not nationals of the applicant. According to the Gambia, this obligation is undeniable in international customary law because, as the court has stated, and Myanmar acknowledges, the members of a protected group themselves have the right to be protected from acts of genocide and related prohibited acts identified in Article 3. Breaching this right of the individual generates, for the state responsible, an obligation to make to them reparations for the adverse consequences of such acts. The question is nationality or lack of nationality. To go against us, Professor Talmont resorted to the commentary on the ILC Article 28 of the Articles of International Responsibility of States, and that is at the very beginning of Part 2 on the content of responsibility, but he only quoted a brief excerpt of paragraph 3 of the article, of the comment to Article 28. Let me show it on the screen, and it says, and I'll highlight a few things. Article 28 does not exclude the possibility that an internationally wrongful act may involve legal consequences in the relations between the state responsible for that act and persons or identities other than states. This follows from Article 1. Later. State responsibility extends, for example, to human rights violations and other breaches of international law where the primary beneficiary of the obligation breached is not a state. However, while Part 1 of the draft articles applies to all the cases in which an internationally wrongful act may be committed by a state, Part 2 of the articles, starting at Article 28, has a more limited scope. It does not apply to obligations of reparation to the extent that these arise towards or are invoked by a person or entity. In other words, the provisions of Part 2 are without prejudice to any right arising from the international responsibility of a state, which may accrue directly to any person or entity other than a state, and Article 33 makes this clear. It is therefore wrong to argue that the law of international responsibility does not create an obligation of responsibility incumbent on the state responsible in the interest of the victims of the wrongful act. there is that the law, as codified in the second part of the articles, concerns the content of the international responsibility of a state between states. Professor Talman also relied on paragraph 111 of the advisory opinion of the Court on obligations of state in respect of climate change. However, the paragraph only looks at, and I quote, whether or not individuals have an entitlement to invoke the legal responsibility of states or to make a claim. In our case, the Gambia has invoked the legal responsibility of Myanmar, and the court has recognized that it had standing to do so. The excerpt listed from your jurisprudence by Professor Talman, therefore, does not relate to the obligation of reparation in the interest of individuals. Professor Talman also argued that the basic principles and guidelines on the right to a remedy and reparation for victims, adopted by consensus in 2005 by the General Assembly, he argued that these principles are not legally binding and would therefore not create an obligation to make reparation directly to the alleged victims of genocide. Admittedly, the text is not binding as such. Yet it was drafted over many years on the basis of international practice, and it clearly distinguishes between should and shall. And in that respect, it reflects customary law and adds to the codification of the law, as the ILC had only covered obligations of reparation in the interest of states and between states. The 2005 Basic Principles and Guidelines have been invoked and applied in international practice. Thus, the United Nations General Assembly resolution passed in the immediate aftermath of Russia's invasion of Ukraine referred to it and affirmed Russia's obligation to make reparation for the damages suffered by private individuals because of the war. The Council of Ministers of the Council of Europe established the Register of Damages for Ukraine, referring to the very same basic principles and guidelines. This practice not only indicates that states consider that an obligation of reparation in the interest of victims exists in customary law, but it also confirms that the right of other states than the injured state to request its performance in the interest of victims. Twice, the court also recognized the existence of an obligation to repair and the obligation of reparation in the interest of victims. First in the advisory opinion on the wall in 2004 and 20 years later in the advisory opinion on occupied Palestinian territories. Myanmar argued that in the wall opinion, the court hadn't ruled on the question of whether non-injured state had a right to claim reparation in the interest of Palestinians. And that is true, but that isn't the question. The Gambia relies on your 2004 jurisprudence to argue the existence, the very existence of an obligation of reparation in the interest of individual victims. In 2004, you confirmed the existence of such an obligation in the following words, and I quote, wrong slide, maybe? Wrong slide still. In 2004, then, 2024, correction of the interpreter, Israel is under an obligation to provide full reparation for the damage caused by its internationally wrongful acts to all natural or legal persons concerned. The subsequent paragraphs in the opinion are dedicated to the forms the reparation must take. The General Assembly approved the court's opinion, thus confirming the states recognize in their contemporary practice that an obligation of reparation in the interest of the beneficiaries of the obligations breached does exist in customary law. Myanmar has said nothing of your 2024 opinion or of its reception by states, even though it voted for the General Assembly resolution which endorsed it.
I now turn to the matter of whether the Gambia has standing to request performance by Myanmar of its obligation of reparation in the interest of Rohingya victims. We recognise that this question was not explicitly ruled on in your 2022 judgment. This judgment, in paragraph 112, addresses only the standing to find that, to have it found that a breach of ege omnes partes obligations has taken place, and to have an end put to it if it continues. We can only deduce from this paragraph that the court ruled out any... We cannot deduce from this paragraph that the court ruled out any right for the Gambia to invoke the responsibility of Myanmar in order to request performance of its obligation of reparation in the interest of Rohingya victims. What's more, Myanmar did not claim that your judgment is a res judicata along the lines of a contrario negative implication. Rather, through a positive logic implication, we could think that the court also accepted the Gambia standing in this regard, since Myanmar was opposed to its standing in all regards, including the purposes of the matter at hand. If your 2022 judgment did not contain an implicit determination on the matter, the court should now make that determination. Contrary to what Professor Talman stated, this question is not a matter of international customary law. Indeed, this is not a matter of a new specific obligation incumbent upon Myanmar, the existence of which should be found in the theory of sources of law. The obligation of reparation in the interest of victims is certainly of customary nature. It's an obligation of customary nature. But the standing of the Gambia to request its performance adds nothing to this obligation. It does not add additional weight to it, does not weigh on it. This standing exists independently, and the standing of the Gambia in this regard is a logical consequence of the collective character of the obligations breached and the fact that the beneficiaries of those obligations are citizens or rather sub-citizens of the state responsible. Members of the court, when the court ruled in Belgium versus Senegal, or in this case, on the applicant's standing, no reference was made to customary law, and no examination of a general and constant practice accepted as law was undertaken. The reason is simply because the legal question at stake was not the existence or non-existence of an additional legal obligation incumbent upon the respondent. Thus, the ILC was able to put forward Article 48, paragraph 2b, without a prior examination of the constituent parts of custom, and the court sanctioned the solution in 2025 without doing so either. The Myanmar's argument in this regard merely recycle the arguments it put forward in the preliminary objection stage on the basis of the principle of the nationality of claims. These arguments were rejected by the court and must not be examined or re-examined from the point of view of the theory of sources or customary law. Thus, paragraph 443 of the advisory opinion on climate change reflects the state of the law, and Professor Talmant did not claim that you were mistaken. Myanmar, however, alleged that the Gambia did not have standing because the Convention does not grant victims the right to invoke the responsibility of Myanmar, and that it does not provide for a right to reparation in their favour. As I've said, this right automatically exists under customary law. According to Myanmar, this requirement allegedly stems from Article 48.2b, in that it concerns, and I quote, the performance of the obligation of reparation in accordance with the preceding articles, end quote. The mere reading of this provision allows us to understand that the argument is flawed. Indeed, this phrase in accordance with the preceding articles simply states that the performance of the obligation of reparation must take place in accordance with the preceding articles, and not that the preceding articles are the basis of the obligation of reparation or the request of reparation. I now come to the requested forms of reparation, to which Myanmar drew very little attention. Regarding restitution, the court specified in the pulp mills case that, like other forms of reparation, restitution must be appropriate to the injury suffered, taking into account the nature of the wrongful act having caused it. And the court quoted the Avena judgment to support this. The requested restitution measures are especially appropriate to the injury suffered by victims of genocide, given the nature of that wrongful act. Of course, it will be for the court to decide. During the first round of pleadings, I drew the court's attention to the two first restitution measures requested. You have since heard our witnesses. To return to their land is their dearest wish, and their request is certainly representative of a great number of refugees. The Gambia's request in this regard is not at all for an obligation of return for refugees, but of an obligation for Myanmar to allow for this return to take place in safe and dignified conditions, and an obligation for Myanmar to return individual and collective property. Concerning the third measure, a restitution measure concerning the reunification of families, is also essential according to us. Concerning the other forms of restitution requested by the Gambia, they are just as necessary and appropriate to the injury suffered, taking into account the nature of the wrongful act having caused it. These measures reflect the 2005 Basic Principles and Guidelines, and I would refer you to our written submissions on this matter. Myanmar alleged that, in the absence of more detailed identification of the victims, the court should abstain from ordering any reparation. However, the group of victims is perfectly identified, and the lack of precision as to the exact scale of the damages was never an obstacle to the court affirming in the judgment on merits that the respondent had an obligation to provide reparation, if, of course, the alleged harm had taken place, which is assuredly the case in the present case. For the remainder, the Gambia is requesting, in accordance with the court's usual practice, that the precise identification of the material and non-material harm, its scope and evaluation be examined at a later stage of the proceedings. However, Mr. President, members of the court, the requested restitution measures cannot wait, because to wait would amount to tolerating the persistence of major harmful effects of genocide. The Gambia is thus requesting that the restitution measures asked for be ordered without further delay. Mr. President, members of the court, I now come to the last question. Assurances and guarantees of non-repetition. Here the debate bears on 3 points: the right of the Gambia to request them, the need to order them, and the appropriate character of the measures requested by the Gambia. As to the right of the Gambia to request guarantees of non-repetition, I can be brief. Given what I said during the first round, this is not a question of customary sources or basis. Paragraph 443 of your advisory opinion is also authoritative on that point. Regarding the need to order them, we need to see whether the circumstances so require. as laid down in Article 30b of the Articles of the ILC. The parties agree on this condition, and they agree on the fact that it is for the court to decide. You know the radically opposed positions of the parties on this matter. But as opposed to what was said, the Gambia is not only invoking the character of the breached obligations and the gravity of the breaches to justify its request. To the points I made during the first round, and you might remember them, to those points I would add the following. In the Provisional Measures Order, the court had pointed out, and I quote, that Myanmar has not presented to the court concrete measures aimed specifically at recognizing and ensuring the right of the Rohingya to exist as a protected group under the Genocide Convention. End quote. Have things changed since then, in the last 6 years? Absolutely not. However, the binding effect of your order is about to end with your judgment, but the rights that you protected while you make your determination on the merits are just as seriously threatened. Members of the court, that is why guarantees of non-repetition are warranted. What guarantees? Those that you will deem appropriate. Appropriate here means bringing about what is required to effectively protect the rights of the members of the Rohingya group under the convention, so that hell is no longer unleashed in Rakhine, is not unleashed in Rakhine State when they return. That is why, at the very least, we should guarantee that they be able to find in Myanmar the place that is owed to them and that they deserve. You know what is the guarantee of non-repetition that is requested by the Gambia, and you also know the discriminatory reasons for which Myanmar is opposed to them. Perhaps more is needed, and that is within your power. Mr. President, I would conclude by providing some answers to the second question asked by Judge Cleveland, as follows.
Decisions of other international courts, tribunals or bodies that either party considers relevant to the propriety or appropriate scope of such remedies, should those questions arise in the case.
Madam Judge Cleveland, the answer to that question is potentially very broad if we indeed intend to cover all of the jurisprudence and practice in matters of remedies. I would limit the response of the Gambia to a few elements which appear to be more directly pertinent concerning property restitution and guarantees of non-repetition. Regarding property restitution, the Commission for Real Property Claims of Displaced Persons and Refugees, which was set up by the Dayton Peace Accords for Bosnia-Herzegovina, is an interesting example from a post-conflict context to benefit individuals. You are certainly familiar with this. The jurisprudence of the Inter-American Court of Human Rights also provides interesting examples of property restitution, especially to the benefit of indigenous communities and concerning their ancestral lands. I'm sure that many members of the court are familiar with this. The return of victims of forced displacement was also ordered as a restitution by the San Jose Court. The African Court of Human and People's Rights similarly ordered the restitution of ancestral lands to an indigenous people. As we know, the Inter-American Court was a pioneer in guarantees of non-repetition, and we could not bring here its wealth of jurisprudence in the matter. A few examples are referred to in footnotes, including in cases where guarantees of non-repetition were ordered to amend nationality laws or to ensure legal recognition of members of a specific group. The African Court of Human and People's Rights also issued measures aimed at the full recognition of an indigenous population. Now, the jurisprudence of regional courts must of course be placed in the specific legal context of the instrument of which they are the guardian and of the specificity of the respective cases. Nevertheless, this jurisprudence provides interesting points of comparison. The present case is in many ways unique and without true precedent. But the rules exist, and as I've shown, there is no obstacle to their implementation. The court is also, in the present case, the guardian of an instrument that protects fundamental human rights. Once again, I thank the court for its kind attention, and may I ask you, Mr. President, to call His Excellency Attorney General Jallow, agent of the Republic of the Gambia, to the podium for a few concluding words, and so that he might read the Gambia's final submissions.
Je remercie le professeur Dargent,
I thank Professor Dargent.
agent of the Gambia. High Excellency, Mr. Dauda Jallow, you have the floor, Excellency.
Mr. President, esteemed judges, it is my honor to conclude the Gambia's presentation in these oral proceedings and to read out our final submissions. You have heard over the past 3 weeks the extensive evidence presented by the Gambia of Myanmar's commission of genocide against the Rohingya group in northern Rakhine State, as well as other violations of the 1948 Genocide Convention. This evidence, drawn from independent, credible, and authoritative sources, is fully convincing that Myanmar committed genocide. The matter is now in the hands of this august court. We trust that, as the guardian of the Genocide Convention, the court will discharge its duty to uphold the rights of the Rohingya as a protected group under the Convention by holding Myanmar accountable for its violations of the Convention. We further trust that, as the principal judicial organ of the United Nations, the court will do justice to the efforts of the United Nations and so many of its bodies to honor the commitment of the Convention's drafters to prevent and punish genocide. In his opening remarks, Myanmar's agent stated that a judgment holding Myanmar responsible for genocide would, I quote, place an indelible stain on Myanmar and its people. That has the matter backwards. It is Myanmar's military's commission of genocide that has left the stain, and it is only through truth and accountability that the stain can be removed. A judgment from this court declaring truth about Myanmar's genocide of the Rohingya and ordering appropriate remedies, including measures for reparations, will help to break Myanmar out of its cycle of atrocities and impunities, a cycle that currently has the senior general who oversaw the genocide ruling the country by dint of brute force. The Rohingya people and the people of Myanmar deserve justice and accountability. It is our sincere hope and expectation that this honorable court will deliver. Mr. President, members of the court, I would like to extend our sincere appreciation for all the efforts of your distinguished registrar and the entire registry staff. who handled the complicated logistics for these hearings with impeccable skills, diligence, kindness, and dedication. I also want to thank the interpreters for their customary flawless performance, especially given the unique challenges posed at these hearings. And I would also like to thank you, the eminent judges, for your keen and courteous attention throughout these proceedings and for your thoughtful questions. I will now read out Gambia's final submissions. The Republic of the Gambia respectfully requests the International Court of Justice to adjudge and declare that, 1, the Republic of the Union of Myanmar is responsible for genocide against the Rohingya group perpetrated by its security forces and individuals acting under their instructions, direction, or control during the clearance operations of 2016 to 2018 in northern Rakhine State, in violation of Article 1, Article 2, A, B, C, and D, and Articles 3A of the Convention on the Prevention and Punishment of the Crime of Genocide, the Convention. The Republic of the Union of Myanmar has failed to prevent acts of genocide perpetrated by individuals alongside its security forces during the clearance operations of 2016 to 2018 in northern Rakhine State, in violation of Article 1 of the Convention. The Republic of the Union of Myanmar has directly and publicly incited acts of genocide in violation of Article 3C of the Convention. The Republic of the Union of Myanmar has failed to punish acts punishable under the Article 3 of the Convention in violation of Articles 1, 4, and 6 of the Convention. The Republic of the Union of Myanmar has failed to enact the necessary legislations to give effect to the provisions of the Convention in violation of Article 5 of the Convention. As a consequence of its responsibility for these violations of the Convention, the Republic of the Union of Myanmar must cease forthwith any ongoing internationally wrongful act referred to in paragraphs 3, 4, and 5 in particular. Take immediate and effective steps to suppress and prevent any direct and public incitement to commit genocide. Take immediate and effective steps to enact specific and complete genocide criminal legislations applicable to all individuals, addressing all prohibited acts under Article 3 of the Convention and providing for adequate and severe penalties. Take immediate and effective steps to submit to trial before an independent and effective tribunal, including before an international penal tribunal, those members of its armed forces, police and other security forces, or any other persons within its jurisdiction who are suspected on probable grounds of having committed acts of genocide referred to in paragraphs 1 and 2 and punishable under Article 3. Shall provide reparations for the victims of the genocide referred to in paragraph 1 and the acts of genocide referred to in paragraph 2 who are members of the Rohingya group, and shall, 1, by way of restitution, allow the safe and dignified return to their place of residence of displaced members of the Rohingya group, whether they are displaced within Myanmar or abroad. Return to the Rohingya